Ignition sequence starts. 6, 5, 4, 3, 2, 1, 0. Liftoff. We have a liftoff.
Hey everybody, this is the Digital Asset Investor, and I'm going to risk getting in trouble this morning. There are people asleep in this house, and I'm just going to take the chance because we have so much interesting news that came in yesterday afternoon and yesterday evening that it's got to be done. So I may get yelled at for this, but that's okay. And yes, the Digital Asset Investor does get yelled at occasionally. Okay. So first of all, before we get going, I wanted to show you this from Times Square. Here's a link to on the NASDAQ. And they said, keep looking out for the recent interview. The COO of Link2, Joe Indoso, went up to New York with PolySign CEO Jack McDonald. And I don't know if they did the interview jointly or how they did it, but it's coming out this week. So, and Link2 is one of my sponsors. The link's in the top of the description. They do have PolySign private equity. This was a good one I woke up to this morning. This guy's on a roll. eGrag Crypto, XRP, Nike swoosh, $27. I don't even know if he just made that up this morning or if that's an actual thing. A Nike swoosh charting, I don't know. But he goes on about this and measuring the troposphere line, never heard that one either, to the lowest point in the Nike swoosh, March 2020, and trying to fit in will hit $27. It gives us 23rd of November 2023. Bitcoin pumped 2,114%, ETH 5,890%, but XRP cannot pump 7,500% from current price. It's laughable. Now, see, the part he doesn't say in here is before all the FUD and the lawsuits and the lies and everything else, back in 2017-18, XRP pumped more than any of them at over 38,000%. I think that was the number. So yeah, it can do it. Okay, this came out yesterday afternoon and I was like, whoa. Shocking new case filed by the SEC. The SEC has just filed a case alleging that selling crypto mining equipment and offering hosting services for equipment constitutes an investment contract under Howey. Yes, you read that right. Here's what you need to know. The case was filed in federal court in Utah. Some of the mining machines at issue are Bitcoin ant miners. To my knowledge, the SEC has never issued guidance, formally or informally, that even hinted that selling mining equipment could be an unregistered securities offering. Now, to me, when I read this, I was like, well, this is the SEC literally this is an idea to tie up proof of work for the next 2 years. That's the first thing that I thought. But I thought some other things, and we'll go over those. The first is pointed out here by Crypto Law. That might be surprising news to William Hinman, whose law firm Simpson Thacher shepherded the IPO of a Chinese mining company, Canaan, this was back when Bill Hinman was at the SEC. They helped take a Chinese mining company public, this Canaan. Okay, so but this is how corrupt our SEC has become. They're helping take a mining company public just a couple of years ago, and now they're suing over saying mining equipment is a security. Does that make any sense? Then you've got this, John Deaton. This is where the next attack by the SEC on Bitcoin will come from. You can see this. You can see it forming, folks. So you've got Senator Warren leading a group of 50 lawmakers putting pressure on Gary to not back down on forcing public companies to disclose information about their carbon. Lawmakers say investors are demanding the information. Investors don't give a rat's behind about carbon emissions. This is pure corruption where the SEC is trying to involve this at the SEC, and it has absolutely nothing to do with what the SEC's function is. But this is about an attack. I'm convinced it's about an attack on Bitcoin and proof of work. But it's not a coincidence that Ethereum changed over away from proof of work, and now all of a sudden, after 10 years, they're taking this angle, and they're taking the angle of that mining is a security, selling mining equipment. And then Baba Kugs, I was literally in a conversation with somebody on the phone talking about this issue, and I was talking about the same thing that Baba Kugs puts out here. Look at this. This is from Kendra Hill a few years back on social media, one of the people that disappeared. Cryptocurrency will be made illegal. This is not a maybe, this is a warning. Nothing is left up to chance. Our world is always planned years in advance. If you fail to plan, you are planning to fail. And failure is not an option. Allowing additional currencies to exist when the world is only using one would be disruptive. So it will not be tolerated, and it will be easier to stop than you think. The illusion is that Bitcoin, for example, is untouchable. The reality is that it is government controlled through the use of mining pools. If it's government controlled through the use of mining pools and they're now attacking the mining itself, you add 2 + 2, folks. Any cryptocurrency aiming to be decentralized digital currency will not survive. The one that we will use has already been chosen. What have we called XRP for all these years? The one? All right. Now it's time to talk about the XRP case, because it is on like Donkey Kong, folks. We're about to get a ruling on this thing. This came out yesterday evening at 6:52. James Flant, breaking. Judge Torres issues ruling on parties' motions to preclude expert testimony. So we're going to go through all the issues that came up in this. Eleanor Terrett, breaking. Judge grants Ripple's motion to exclude expert number 1, Patrick Doody, from testifying about the perceptions of reasonable XRP purchaser. The SEC previously hired Doody to analyze the expectations of token purchasers in its case against Telegram, which it won. If you remember, Doody is the guy who John Deaton was all over it. He's the guy that never interviewed one XRP holder, okay? He's also this guy. Remember when this stir was going on? Eleanor Terrett had tweeted this out in May of 22. Scoop, Patrick Doody, the independent expert the SEC retained to analyze the perspective of a reasonable purchaser of XRP, is currently employed by a private consulting firm that won a $4.1 million government contract in 2018. The contract was funded by the SEC. This is the corruption we've been dealing with. And apparently the judge smelled what the SEC was cooking. John Deaton said they literally, Eleanor Terrett says, it's worth noting the SEC lawyers tried to get Judge Torres to ban John Deaton from participating in the case, partly because he disclosed the name of their expert witness. Not only did she not ban him, she agreed with him that Doody shouldn't testify about XRP holders. And John says they literally asked the judge to revoke my amicus status over my motion asking permission to file an amicus brief challenge this so-called XRP holder expert. These Ivy League SEC lawyers aren't the best poker players, I take it. Shot at them. Okay, and then John comes in and he says their motion to exclude expert number 1 from testifying is granted. In his first opinion about the perceptions of reasonable XRP purchaser denied. Judge Torres, now try and tell me XRP holders don't make a difference. Then this guy says, thanks, John. Does this give any suggestion or hint in the remaining timing till summary judgment? This is the best thing I read last night. I seriously doubt that we see a significant delay from here. Could be tonight or in a couple of weeks. So we're literally within a couple of weeks max on this thing, is the way John Deaton sees it. Jeremy Hogan, the SEC has to prove that you had a reasonable expectation of profits from the Ripple's efforts, and the judge just stuck the SEC's only expert witness on the subject, struck, that is. So now, how the heck can the SEC prove reasonable reliance? Who will testify? Just thinking out loud. All right, then there was a Twitter Spaces last night. This first clip is Fred Rispoli, who's an attorney, weighing in.
She does make a few references where, hey, this is something that really is going to be hotly contested that I think would preclude summary judgment. But, more in line with what Jeremy's saying. She did make a lot of also side comments like, I'm really going to be narrowing this down, and you don't have a lot, as Jeremy said, to hang your hat on SEC. Like, this is going to be set up where it's going to be hard for you to win. And, again, that could be, not only is that legally correct, but that's also her telegraphing, you can still settle this on some more favorable terms to you, SEC, if you really want, but your time's running out.
So, Jeremy,
since Fred said the S word, Fred said the S word about me. That did cross my mind as well. Oftentimes judges will kind of telegraph how things might go, and that's kind of the wink, wink, nudge, nudge to one side or the other to say, if you don't want it to go that way, maybe it's time to start talking to the other side. But I didn't say it, Fred did.
All right, and then there was another clip here, right here.
Thinking
this is Jeremy Hogan speaking.
That last prong is where she's going to hang her hat. If she's going to rule in Ripple's favor, you could see where she's almost setting it up to say, well, they don't have any evidence of a reasonable expectation of profits, and the expert that they do have doesn't really bring a lot to the table, and therefore no reasonable jury could find against Ripple, since the SEC has the burden of proof. And so you could kind of see so it could be either way. I'm not saying that it's not going to trial, but she could also be setting it up for a summary judgment ruling. And if that's the case, you got to be pretty happy if you're Ripple right now.
Sounds good to me. Now, Eleanor Tarrant points this out. Larger than the filing, Torres references at trial twice. Is this any indication of how she's going to rule? So, and let me see if I put it here. Here it is. No matter how SEC versus Ripple is resolved by Judge Torres, conventional wisdom is that losing side will appeal. When it does, this case may become the vehicle by which the administrative law itself is transformed. No matter what Judge Torres decides, litigation over the Ripple case and the SEC's other crypto regulations will continue for years, as the legal questions are far too big for the district court to resolve. So the overall, what I got out of this, the overall opinion was a couple of things. The first is that at least a portion of this is probably going to go to trial. I got that out of it. And what I'm hoping for is that they say the XRP in the secondary markets, XRP itself and in the secondary markets are not a security. And then we're going to take this, and this to trial. Okay, that's what I'm hoping for. But as you heard in that one clip, this judge is kind of leaning towards the SEC and towards Ripple, but it's kind of like she's saying to the SEC, look, this isn't going to be as favorable to you, so you might want to look at settling this with some better terms for yourself. And Mr. Intuitive, the official cool guy of the Digital Asset Investor channel, brings this up. And he says, don't forget about those Hinman documents. Folks, I stand by what I said. This thing, remember, a settlement can happen before, during, or after this ruling. So I've still got my money on a settlement, and it may be after Gary. Gary's he's a hard-headed little man, and I do mean little man. He's a hard-headed little man, and I believe that he's waiting. I believe he's that kind of stubborn. He's that kind of guy where he's going to wait till the very last minute. He's going to get milk every second out of stalling Ripple. Remember, because this case was a weapon, until the last minute that he can settle based on having all the information, which would mean post-judgment settlement. But I still say we don't ever see those unredacted Hinman documents. We don't see them. Because the powerful people behind it all are going to be saying, Gary, you're going to settle before you're going to put my name out there, Gary. It's not happening. And remember, Gary's a little man. So little men, they're little, starts with a B. My son calls it the B word. That's what they are. And they answer to their masters, and they do what they're told. So that's the way I see this going down. There's a post-judgment settlement. At the very last minute when Gary can agree, that's when he'll agree, when he's milked every single bit of it. That's what cowards do. I'm the digital asset investor. I'm not an investment advisor. This is for entertainment purposes only. Please subscribe, hit the like button, and tell your friends and family that I still think little Gary's going to settle this thing.